Hi, I'm Ben Pilbrow, and I'm a partner in the Commercial Dispute Resolution team at Shepherd & Wedderburn, a leading UK law firm.
And I'm McMillan, I'm a director in the team.
In these videos, we provide an overview of litigation funding in the UK. In this first video, we will explain firstly what litigation funding is, secondly the circumstances in which you might use it, and thirdly why you might consider doing so. In a second video, we are going to consider how to go about securing litigation funding. So, let's start by explaining what litigation funding is. When a dispute arises which cannot be amicably resolved, parties typically turn to litigation or some other form of dispute resolution process. Often they will need assistance from lawyers and experts to pursue the dispute, and the fees of the lawyers and experts can swiftly become significant.
Litigation funding is when a third party with no previous connection to the dispute agrees to finance all or part of the legal costs of a claim. They are known as funders. A funder will typically fund all or some parts of the costs and expenses of solicitors' fees, barristers' fees, expert fees, and court or tribunal fees.
Throughout the claim, the funders will not be involved in the day-to-day running of it, and your lawyers will continue to act for you. However, the funders will receive progress updates from your lawyers, but will not drive the strategy or tactics of your claim.
At the end of the claim, if you're successful, then you will pay the lender a pre-agreed multiple of the funding amount. This is usually around 2 times the amount advanced by the funder. For example, where a funder has invested £100,000, the funder would expect a return of its initial investment plus £200,000, making £300,000 in total. So if a claim settles for £1 million, this would leave an available balance of £700,000 once the funder has been paid. Unlike a traditional loan, litigation funding is non-recourse. That means that a borrower claimant would only have to repay the funder if it wins its claims. If the claimant loses, it would not have to repay any money.
In England, if you lose your claim, a court will normally order that you pay your opponent's costs. This is known as an adverse costs order. If you obtain funding, the funder can also become liable for an adverse costs order. As a result, funders often require that borrowers obtain a specialist insurance policy to insure against adverse cost risk. These policies often only require you to pay their premiums upon success, so in the event you lose your claim, you may not be required to pay anything, further de-risking litigation.
How can litigation funding help you? While we always aim to resolve disputes for our clients as quickly and cost efficiently as possible, clients often tell us they are worried that litigation will be too expensive or risky.
If you are pursuing a claim of sufficient size to support it, litigation funding can assist you in a number of ways. Firstly, funding provides an enhanced budget, allowing you to engage specialist counsel and experts, which are best suited to your case, who may otherwise not have been in budget. Secondly, it can level the playing field if you are bringing a claim against bigger defendants or large multinational corporations who may have significant annual legal budgets. Thirdly, obtaining funding demonstrates to a defendant that your claim is strong enough for a funder to back it. Psychologically, this can really encourage an early settlement.
Lastly, by obtaining funding, you do not need to use your own funds to bring the claim. This means that costs which otherwise would have been spent on litigation can be applied elsewhere. For companies particularly, this can be an efficient way to manage cash flow and the impact of a dispute on the balance sheet.
We hope that this summary explanation of litigation funding and its benefits was helpful. Please check out our follow-up video on how to secure litigation funding, and if you have any questions, please don't hesitate to contact us.